YH Liman. I appear with MN Sadauki and Mustafa Muhammad for the first respondent, my lord.
Yes. Ruling.
As the call pleases.
Can you all hear me?
Very
Yes,
well.
my
I
lord.
can
Very well, my lord, we can hear you.
Okay. And please, counsel, I'll need you to mute your various gadgets because of interference.
As the court pleases.
Thank you. Ruling. The applicant interested party commenced this application against the respondent by way of a motion on notice dated 2nd November 2022 and filed the same date. The applicant in this motion is Kuloma Umara, while the respondents are one, Abdullah Idris, first respondent, and Independent National Electoral Commission, INEC, second respondent, respectively. The application is brought pursuant to section 36(1) and 2 and 243A of the Constitution of the Federal Republic of Nigeria, 1999, and under the court's inherent jurisdiction, by which the applicant interested party pray for, 1, an order granting leave to the applicant to appeal as a person interested against the judgment of this court delivered on 26th October 2022 in suit number FFCD MCS 15, 2022. 2, an order granting the applicant leave to rely on the documents exhibited in the affidavits in support of this motion and the affidavits in this matter as additional record of appeal, and that this motion shall form part of the record of appeal, being records of this court and which are relevant to the determination of the appeal. 3, for such further orders as this honorable court may deem fit to make in the circumstances. The grounds of the reliefs sought are: 1, the application is germane for the exercise of the applicant's constitutional right of appeal as an interested party whose rights have been infringed by the judgment in suit number FFCD MCS 15, 2022, delivered on 26th October 2022, to which he was not a party and not aware until after the judgment was delivered. 2, the proposed appeal is predicated on a pre-election matter for which time to file processes and determine same are of the essence and are limited by laws. 3, the documents exhibited in support are records of this court, but we are not before it when it considered the cases of the parties and delivered judgment. The said documents are relevant for the determination of the appeal. 4, the court will always do substantial justice as opposed to technical justice. The motion is supported by a 10-paragraph affidavit deposed to by the interested party applicant. The application has annexed to 3 affidavits, 1 by the applicant and 1 by the chairman, PDP Yobe State, and 1 was the legal advisor, PDP Yobe State. And next to the application is the written address and also a further affidavit deposed to by the applicant. And next to the further affidavit is a reply address along with other exhibits attached. 6 documentary exhibits marked as exhibit A, B, C, D, E, and F, respectively. Exhibit A is the proposed notice of appeal. Exhibit B is the membership card of the second respondent. Exhibit C is the letter. Exhibit B is the membership card of the plaintiff. Exhibit C is the letter dated, applicant, I meant to say, dated 22nd September 2022 from the second respondent to the Nigerian police. Exhibit D is the letter dated 23rd September 2022. Exhibit E is the list of delegates of the second respondent that confirmed the applicant's candidacy at the Special Congress of the second respondent. Exhibit F is the letter dated 26 September 2022 of the second respondent informing the third respondent of his candidacy. Then the deponent stated the facts. The deponent, being the applicant himself, gave rise to this, the facts that gave rise to this application as follows: that the applicant is the returned candidate of the second respondent in respect of the Special Congress for Gujiba Gulani, Tarmoa and Damaturu Federal Constituency of the House of Representatives in the 2023 general elections. The applicant became the second respondent returned following its conduct of fresh Special Congress on 26th September 2022, following the death of one Muhammad M. Bukar, a sole consensus candidate, who became a candidate.
Mr. Follin ya dan tashi, Mr. Girma. Ya je bakin gate bari yana zuwa, ya je karga ya can ma yana zuwa.
Somebody can who became the candidate following the conduct of a fresh Special Congress upon the first respondents, a sole candidate in the initial Special Congress, withdrawal from the race, and that the first respondent filed suit number FSC-DM CS15-2022 to purportedly recover the mandate he gave up and wherein judgment was delivered on and was surprised on getting news of the judgment because his rights are seriously affected by it. And this and if this application is not urgently heard, he will be denied his constitutional right of appeal, and that he is desirous of prosecuting this matter to its logical conclusion, particularly because his political career is at stake and he was not heard before decision affecting his rights was delivered. And in proof of his seriousness in prosecuting this appeal, and because of the statutory limitation for filing appeals in a pre-election matter, a proposed notice of appeal is annexed, is exhibited thereto. The deponent stated that if this application is not heard and granted timelessly, then he will not have room to pursue his rights and seek justice. There is also a written address of applicant counsel, Musa Charles Esquire, wherein he submitted a loan issue for determination in this application as follows: if the court should exercise its discretion in the applicant's favor. I will skip the submission of Leonard's counsel. In response to the application, the first respondent filed a 4-paragraph. Well, let me just read one or two things. Applicant counsel submitted that he adopts and relies on and incorporates by reference herein the grounds on the face of the motion and the facts deposed to in the supporting affidavit as arguments in support of this application, and further submits that it's tried law that in the determination of his rights, a party should be heard, indeed, given a fair hearing before any order is made against it. Applicant filed this application and the notice of appeal to protect his rights and praised that the Honorable Court would exercise its discretion in his favor by granting the relief sought. And in doing so, the applicant relies on Section 242 sub 1 and 243A of the Constitution of the Federal Republic of Nigeria. Counsel submitted further that the applicant's notice of appeal shows arguable grounds of appeal as required by law, and that the applicant has made the following points inter alia in this application. A, his rights are affected by the decision of this court in FSCD CS 15/2022, to which he was not a party and not aware until after the judgment was delivered. B, his notice of appeal shows arguable grounds of appeal. C, he would be greatly prejudiced if this application is refused, and pray the court to grant the reliefs as prayed. In response to the application, the first respondent filed a 4-paragraph counter affidavit in opposition, dated 4th November 2022 and filed 7th November 2022, deposed to by one Ali Idris, a biological brother and personal assistant of the first respondent, and by virtue of his position, conversant with the facts of this case. That contrary to the deposition in paragraph 4 of the applicant's affidavit, the first respondent has been validly declared the rightful candidate of the second respondent by a well-considered judgment of this honorable court, delivered on the 26th day of October 2022, and the primary election of 15th July 2022, which produced the late Mohammed M. Bukar, has been declared null and void. The applicant was, and that going by the depositions in the affidavit in support, the applicant was directly and constructively aware of dependency of suit number FSC DMCS 15/2022 between Abdullah Idris versus Mohammed M. Bukar, People's Democratic Party and Independent National Electoral Commission, filed on the 27th day of July 2023, wherein the first respondent sought to recover his candidature unlawfully taken away from him, and that while the suit was pending, Mohammed M. Bukar passed away, and subsequently his name was withdrawn and struck out by this honorable court on the 19th day of September 2022. In his written address dated 4th November and filed 7th November 2022, the first respondent's counsel, Y.H. Liman Esquire, submitted 3 issues for determination. 1, whether in the circumstances of this case, the applicant has satisfied or fulfilled necessary conditions for the grant of the instant application. 2, whether the applicant is a party vested with local standard to appeal this case as an interested party, having regards to Section 285 of the 1999 Constitution of Nigeria and Section 84 sub 14 of the Electoral Act 2022 that defines a party to a pre-election matter. 3, whether the Honorable Court has the jurisdiction to grant the applicant the leave for documents attached to his affidavit to form part of the record of proceedings. Learned Counsel submitted, I'll skip the submissions of Learned Counsel as well. Counsel concluded by submitting that in line with the above submissions, he urges the court to refuse the prayer as the applicant lacks any legal right to protect a meddlesome interloper who was fully aware of dependency of the suit but stood by and watched, and that on the whole, the applicant's application is incompetent and incurably defective to warrant the intervention of this honorable court and its exercise of discretion in his favor, and urge the court to dismiss the application with punitive cost. The interested party, applicant, in response to counter affidavit of the first respondent, filed a further affidavit of 3 paragraphs and 3 exhibits, deposed to by the applicant. The exhibits being Exhibit Kuloma J, proposed notice of appeal number 2, Exhibit Kuloma H, letter dated 12 September 2022 of the Yobe State chapter of the second respondent, to the headquarters of the second respondent, conveying the news of the death of Mohammed M. Bukar. Exhibit Kuloma I, letter dated 20th September 2022 of the second respondent to the third respondent, informing it of the fresh primary slated for 26 September 2022. Learned Counsel Charles Musa Esquire argued in the reply address by stating that contrary to paragraph 3D, there's nothing in the affidavit in support or the affidavit of facts deposed to by Ahmed Waziri Esquire and Ambassador Senator Umar El Gash to infer that the applicant was directly or constructively aware of this suit whilst it was pending. The applicant maintained that he only became aware of the suit after judgment was delivered. The learned counsel to the second defendant submitted orally in court that on their own part, they have not filed any process on behalf of the second respondent and are thereby not opposing the application. The third defendant, on the other hand, did not file any process in respect of this case, nor appear in court. The above are counsel arguments and submissions for and against the application to grant as a person interested against the judgment of this court, leave as a person to grant leave as a person interested against the judgment of this court delivered on 26 October 2022 in suit number FSC DMCS 15/2022. This court, having gone through all the processes filed in respect of this instant application, will utilize a sole issue to determine same to it, whether in the circumstances of this case, the applicant has satisfied or fulfilled the necessary conditions for the grant of the instant application. The test to be applied in determining whether or not a person is as an interested person is in an appeal involves determining whether or not such person could have been joined in the suit from the outset, whether that person will be aggrieved or likely aggrieved, or will be affected or likely affected by the decision of the court. This is the position of the Supreme Court in Any Bros Food Processing Company Limited and another versus NDIC 2007 LPELR, where the Supreme Court held, I quote, "The test of interest to determine a person interested is whether the person could have been joined as a party to the suit. A person interested includes a person affected or likely to be affected or aggrieved or likely to be aggrieved by the proceedings." See Ojukwu versus Military Governor of Lagos State, number 1, 1985. Mbanu versus Mbanu, 1961. All Nigerian Law Report. Maja versus Johnson, 1951. Inre Ogun Mohola, 1996 to NWLR. Aliu versus Adewi, 1996, etc., etc. The question to ask is whether the applicant has satisfied or fails to meet any of the above mentioned conditions. The first respondent originating summons was filed on the 27th July 2022 and amended portion to the order of this Court on 19 September 2022, challenging his wrongful and illegal substitution with the deceased Mohammed M. Bukar by the second respondent, as at the time the suit was filed. The parties contending the ticket in dispute were the first respondent and the deceased Mohammed M. Bukar, who hitherto was the first defendant in the suit, alongside the second respondent as second defendant, and the third respondent hearing as the third defendant before the said Mohammed M. Bukar was removed from the suit upon his death. Now, as evidenced by the deposition in paragraphs 4 and 5 of the affidavit in support of this application, the applicant deposed that he became the sole consensus candidate of the second respondent for the Gujiba, Gulani, Termo, and Damaturu Federal Constituency of the House of Representatives for the 2023 general elections in the special Congress held on the 26th September 2022. From the stated facts, it becomes manifestly clear that the applicant cannot qualify as a person or party who could or ought to have been joined as a party to the suit, as he had no right that could have been likely affected by this court decision. Neither will he have had any cause for grievance with the decision of this court at the time the suit was filed or subsequently amended on 19th September 2022. This honorable court agrees with the submission of learned counsel to the first respondent that the applicant was fully aware of the pendency of this suit number FSCD MCS 15/2022, which was contested by the second respondent. Exhibit D attached to the applicant's affidavit was authored by a lawyer from the second defendant's office and by the doctrine of estoppel by standing by, if at all the applicant has any legal right, same is deemed to have been waived. In the case of Bello versus Fahishe and others, 1999 LPELR, the Supreme Court held that, I quote, the principle of estoppel by standing by is that if a person was content to stand by and see his battle fought by somebody else in the same interest, he is bound by the result and should not be allowed to reopen the case or his case. The applicant, being fully aware of the pendency of suit number FSCD MCS 15/2022, but choose to ignore and do nothing about it until judgment was delivered. Therefore, even if the applicant has derived any right on the 26th day of September 2022, he ought to have applied to join his suit, to join suit number FSCD MCS 15/2022, which was then pending and unheard. But the applicant decided to remain a spectator rather than a gladiator, an onlooker rather than a player, who was content with the second respondent to fight his battle, who eventually lost it for him and therefore lacked legal right to be protected as captured by Nweze JCA, now JSC, in the case of Oyetunji versus Awoyemi and others, 2013 LPELR. I quote, my lord, Nweze JSC held such a party is thus stopped because he omitted to intervene in the pending action affecting his interests, although he was not a party thereto. See Bello versus Fahishe 1999, Ungu versus Unagbo 1999. So, where a person is content to be a spectator rather than a gladiator, an onlooker rather than a player, the doctrine will apply. See Anyaoke versus Adi 1986, Opala versus Beme 1989, etc. Flowing from the above, this honorable court holds that the applicant was neither a party whose presence was required in the suit before the real issue or issues in controversy can be settled, nor party that needs to be joined to protect any interest, as he has none. Fortified in this line of thinking by the position in the decision of the Supreme Court in Nigerian Customs Board 2022 Legalpedia, where the Apex Court held, I quote, "The principles governing the grant of leave to an applicant to appeal as an interested party is provided for under Section 2335 of the Constitution of the Federal Republic of Nigeria. An interested party is one whose presence is in a suit is needed before the real controversy between the contending parties is settled. The applicant," end of quote, "the applicant hearing did not demonstrate how the suit he sought to appeal as an interested party would not be fairly dealt with in his absence. The applicant has a duty to adduce by way of affidavit evidence good and substantial reasons why he failed to join the suit during its pendency, as held in Nigeria Customs Board 2022 LPELR. An applicant, where it was held, an applicant seeking for leave of court to appeal as an interested party must make a detailed deposition in his affidavit in support of the application to show A, his interest in the matter, B, why he was not a party in the trial court, C, good reasons for the delay in filing the application. The law is settled that in application for leave to appeal as a person interested, the applicant must, amongst others, satisfy the conditions of disclosing good and substantial reasons why the application should be granted, and the proposed grounds of appeal must also disclose issues of facts and law that the appellate court cannot dismiss with a wave of hand. The applicant failed to discharge the burden of proving any of the mandatory conditions as is required of him, so hold. See Ogembe versus Usman and others, 2011, LPELR, Holman Bros Nigeria Limited versus Kigo Nigeria Limited and another, 1980. Consequently, this honorable court, having realized that from the affidavit in support of the applicant's instant application, no convincing or substantial reasons that are material or essential offered by the applicant in proving the existence of any right or interest in his favor or in explaining why he failed to join the suit during its pendency. On this basis, amongst others, this application of the applicant is refused. The crux of the first respondent's grounds in suit number FSC DMCS 15/2022 was that having emerged as the valid candidate of the second respondent in the upcoming general elections for Gujiba, Gulani, Tarmua, and Damaturu federal constituency, he was wrongly substituted contrary to the provisions of section 31 and 33 of the Electoral Act, and that the primary election of 15 July 2022 that produced the late Mohammed M. Bukar was illegal and void. Now, the applicant herein was not an aspirant to either of the earlier or later primaries. Thereby, the applicant cannot bring himself within the force of section 84 sub 12 of the Electoral Act 2022. The applicant has in paragraphs 3 and 4 of his affidavit stated he is the returned candidate of the Gujiba, Gulani, Tarmua, and Damaturu federal constituency of the House of Representatives in the 2023 general elections. The Electoral Act has set out preconditions that must be complied with before a political party produces a candidate for an election. One of such guidelines is that the third respondent, INEC, must be given at least 21 days notice before the state primary election to enable INEC monitor the election/nomination. And a candidate whose nomination is less than the mandatory 21 days notice to INEC is not qualified to contest election. According to section 82 sub 1 of the Electoral Act 2022, which provides that every registered political party shall give the commission at least 21 days notice of any convention congress, conference, or meeting convened for the purpose of merger and electing members of its executive committees, other governing bodies, or nominating candidates for any of the elective offices specified under this act. Drawing from the above, in this case, the notice sent to the third defendant, as can be seen on the face of the Exhibit D attached to the applicant's affidavit, clearly shows that the letter carrying the said notice was received by the third defendant on the 23rd day of September 2022, and 3 days later, the purported special congress took place on the 26th day of September 2022. It therefore simply means that there was a flagrant violations of sections 81, 82 sub 1, and 84 sub 1 of the Electoral Act 2022 by both the applicant and the second respondent, which rendered the purported Congress null and void. Section 82 sub 5 of the Electoral Act. You need to come on, my battery is going low. Confirm whether it's still, quickly please, before it goes off completely. Okay, it's okay. Thank you. Section 82 sub 5 of the Electoral Act 2022, which provides failure of a political party to notify the commission, as stated in subsection 1, shall render the convention, congress, conference, or meeting invalid. It is well settled law that where a legislation lays down a procedure for doing a thing, there should be no other method of doing it. Thus, where a notice of primary election given to INEC, whereas a candidate emerged as a candidate is short of mandatory 21 days, that candidate is not qualified to contest the election. And if the candidate is the petitioner, he lacks the locus to present an election petition, as it has been held that any violation of 21 days mandatory notice goes to the root of the sponsorship or qualification of a candidate. See APC versus Agbaje 2015 LPELR, also see Dangana versus Usman 2013 6 NWLR. The case of Atai versus Dangana 2012 INEC Law Report, Volume 1, 523, from which the appeal to the Supreme Court in Dangana versus Usman at page 80 to 90 arose, had explained the connection between sponsorship, nomination, qualification of a candidate, and the validity of the primary election out of which the candidate is said to have emerged. At pages, pages 546 and 547 of that case. The Court of Appeal per Ejembe Kojesi A had held, I quote, in the case at hand, the features of sponsorship by a political party are those factors that validate the sponsorship. If there is, therefore, any feature that invalidates the sponsorship, then it is the case that purported sponsorship was not in accordance with due process of law, as in this case. A person who has breached the statute in order to foist or impose himself as a candidate of a political party in an election to an elective post is nothing but an imposter. In the eyes of the law, his failure to meet the due process of law will surely invalidate his attempt to being regarded as a person sponsored by that political party on whose platform he purports to be candidate. Within the meaning and intendment of Section 62, sub 2B of the Electoral Act and other relevant provisions thereof, the first respondent was not qualified to contest the election. The process that purported ushered him in on 28th January 2021 as a candidate of the PDP is seriously flawed. The purported nomination was illegal and a nullity. The case of, end of quote, the case of CPC versus Umbugadu 2013-18 NWLR further underscores the point that for a candidate to emerge and properly acquire the right to be nominated and sponsored by a political party at an election, he ought to have emerged from a properly conducted primary election. Panguta JSC at page 126. My Lord held, I quote, the sole purpose of a party's primary election is the emergence of one of the contestants as the party's candidate at the election. I subscribe to the above view, and I wish to add that there can be no nomination of a candidate and acquisition of vested interest in an inconclusive party primary election. Also, in the case of APC versus Karfi, 2018-6 NWLR, the Supreme Court per ECHO JSC held as follows: the courts are bound to ensure that relevant specific provisions, particularly those mandatory provisions of the Electoral Act, are complied with. It is no longer in dispute that where a political party fails to comply with the mandatory provisions of the Electoral Act on nomination of its candidates before the general election, the court will intervene and declare such purported nomination invalid, and the affected political party, here in the instant case, the APC, will be taken or deemed to have fielded no candidate for the general election. Going from the above, in the instant case, end of quote, following from the above, in the instant case, the applicant was not an aspirant in law, having not been produced by a valid primary election. See the case of Ime Nike versus PDP and others, 2012 LPELR. It is not in dispute that the applicant was not a party to either the primaries that produced the first respondent or the purported one that produced Mohammed M. Bukar, late. In line with the above, the applicant lacks a legal right to protest and therefore has no local standard to make this application. I so hold, and that he is nothing but a meddlesome interloper whose interest did not come within the ambit of Section 84/14 Electoral Act 2022. This application is hereby dismissed. This shall be the ruling of this court.
As the court pleases.
As the court pleases.
We thank my Lord profusely for this erudite ruling, and we wish my Lord success in my Lord's entire career. Having judges like my Lord give us assurance that there is indeed hope for the future. We pray and hope that we will see my Lord one day at the Supreme Court. Thank you, my Lord.
Thank you so much, Counsel.
We thank you, my Lord. We are grateful that my Lord treated this matter with the urgency it deserves. We are most grateful. Thank you, my Lord.
Thank you, Counsel. Thank you so much. Good afternoon, or is it good evening?
Yes.
Okay. Thank you.
We are used to my Lord.
Bye-bye.
We are used to my Lord giving a ruling very fast. We do pray that we'll be able to get a copy today, as my Lord has shown in the past.
Your submission, please.
I said we are used to my Lord giving copies of the ruling very fast. We do pray that we can get that. We continue with this judgment. If we can, we'll be very obliged to get it today as usual.
Yes, then forward your application.
Most obliged, sir. Thank you, my Lord. We shall do so.
Okay, I agree to. Your boy is lawyer, sir.
I'm not here. Someone talking to me.
I said I agree to you, sir. Your boy is a lawyer, sir.
Organiman, well done.
Well done, sir. How are you, sir?
We thank God. We thank God. Thank God.
How is everything, sir?
We thank God. Thank you for everything. Thank you so much.
The journey will continue, and then we keep on meeting in more convenient circumstances. A lot from you, sir.
Thank you. Thank you. Bye-bye.